The Renters' Rights Act comes into force on the 1st of May. Are you ready? Do you know what you need to do between now and the end of July? Well, this video tells you exactly what you need to do month by month. Your action plan. I'm Suzanne Smith, landlord and former corporate solicitor and author of this best-selling book, The Good Landlord Handbook, Succeed as a Landlord under the Renters' Rights Act. I run the Independent Landlord website and this YouTube channel to provide reliable information to everyone in the private rented sector. You can subscribe to my free weekly newsletter to keep up to date here at theindependentlandlord.com/subscribe. Right, let's get started. What exactly happens on the 1st of May? Well, on the 1st of May, existing assured short-hold tenancies, will become APTs overnight, and they'll be treated as one ongoing tenancy. And so from the 1st of May, you will not be able to grant an assured short-hold tenancy. They will disappear from the statute bit. They won't exist anymore. So instead, it would be an assured periodic tenancy. And you must absolutely not enter into any fixed-term tenancies under the Housing Act 1988, because if you do and you purport to let for a fixed term, you could get a civil penalty of up to £7,000. Right, let's go through your to-do list between April and the end of July. So for April 2026, it's get your house in order time. Audit your portfolio. Have a list of every property that you rent out. Is it fixed term AST, already an AST, or solely a verbal tenancy? And this determines what you need to serve by the 31st of May. Review any rent review clauses in existing agreements. These become void on the 1st of May 2026. And if you're due to review the rent between now and the 1st of May, and you try and use a rent review clause, it won't be valid if the new rent will come into effect after the 1st of May. You'll have to wait until the 1st of May and use the new Section 13 process, that's the new Form 4A, which I'll go through shortly. So the next point is to get your documentation ready. Get your new assured periodic tenancy agreement ready for new tenancies that you enter into, which means sign from the 1st of May. And my membership, the Independent Landlord Hub, has draft templates for this. And download the information sheet if you haven't done it already from the government website and start sending it to all existing tenants. There is no need to wait. And you can find the link for the document here on my website, theindependentlandlord.com/renters-rights-to-do. So April is the last chance saloon for serving a Section 21 notice, and don't leave it until the last day. If you're thinking about doing it, get it drafted and ready. The absolute last day to serve it is the 30th of April before 4:30. But in practice, you should really aim to serve it by Monday the 27th at the latest to be on the safe side. Most law firms will stop taking instructions by mid-April. And you won't be able to correct any mistakes by issuing a new Section 21 notice from the 1st of May. So don't do it yourself. Get specialist advice. If you serve the Section 21 notice, it will preserve the AST as an AST, so it won't turn into an assured periodic tenancy, and the notice will need to be valid when it's served. April is also the last chance to increase rent under the old rules. If you want rent to come into effect from the 1st of May using a Section 13 notice, you can serve a Section 13 notice under the current rules, that's Form 4, and you need to serve that before the 1st of May. Serve by Monday the 27th of April at the latest to be on the serve side, and don't forget that you need to give at least a month's notice before the new rent is due to come into effect. And any rent increase under a rent review clause that is due to take effect on or after the 1st of May will not be valid, and you can't serve a Section 13 before the 1st of May if there's a rent review clause. So rent review clauses will become null and void on the 1st of May, and if you have a rent review clause with an increase due after the 1st of May, you can't rely on it. You'll need to serve a Section 13 notice using the new Form 4A, and don't forget you'll need to give 2 months notice and not 1 month's notice, and it needs to expire on the following rent payment date. So have a look at your tenancies now just to see whether you've got any rent review clauses that fall into this gap. Student HMO landlords. If you let full-time students in an HMO and you think you might want to use the new Ground 4A to recover possession this summer, you'll need to serve a Ground 4A written statement on your tenants by the 31st of May. Start planning this now. I have a template in my membership, the Independent Landlord Hub, and you will then have to give 2 months' notice on or after the 1st of May if you wish to terminate this way. You can also have a look at whether you should serve a Section 21 notice before the 30th of April as a backstop for this academic year, but bear in mind that it will lapse on the 31st of July if you don't apply for an order for possession by then. Next step is to prepare your processes. Think about how you'll adopt the new rules from the 1st of May. For instance, no rental bidding. The proposed rent must be stated in listings, which shouldn't be a problem, it normally is anyway, but you're not going to be able to accept offers above that amount. And you can't discriminate against applicants receiving benefits or children. So any adverts that say no DSS or no children, you can't have them unless you've got a good reason to turn them down. For instance, if you've got an HMO, it would be reasonable to say no children. Update your property listings and remove any language like no DSS or similar, and make sure there's the proposed rent, and check that the rent period is monthly with a maximum of 1 calendar month. And then there's the 1st of May, the big Renters' Rights Day, also International Workers' Day. The new regime is live. Well, on the 1st of May, the new tenancy regime comes into force, and all existing assured short-hold tenancies will automatically become assured periodic tenancies by operation of law, and that's the new Section 4A of the Housing Act 1988. And so this happens automatically. You don't have to do anything to trigger it. You can't opt out of it. The only way you would be able to get around it is if it's not a Housing Act tenancy. So it's a high rent tenancy of £100,000 a year, or you've got a lodger. As the APT and the AST are treated as one continuing tenancy, you do not need to reissue safety certificates or re-protect the tenancy deposit. And my best-selling book, The Good Landlord Handbook, explains what we need to do in very straightforward terms with lots of checklists. And it's flown out of the Amazon warehouses since I published it on the 5th of March. You can also buy it from me, and there's a link underneath the video. And something really important. From the 1st of May, do not treat any existing tenancies and existing Housing Act tenancies as if they're still fixed term tenancies, because the fixed term will come to an end on the 1st of May. So for new tenancies from the 1st of May, use an assured periodic tenancy template and don't include a fixed term. Provide the written statement of terms before the tenancy is entered into. The easiest way to do this is in the tenancy agreement, which is what I've done in the assured periodic tenancies in my membership, and make sure the tenant has time to read it before signing. State the proposed rent in all marketing and listings. Do not ask for offers above the proposed rent, and don't accept or request rent in advance before 1 month's rent before the tenancy is entered into. The first rent payment can only be taken once the tenancy agreement is signed, and don't discriminate against applicants because they receive benefits or have children, unless you've got a good reason, as I said. You can still assess affordability and take income into account. And from the 1st of May, you no longer have to serve the How to Rent booklet. Now we moved on to July, and the big deadline is the 31st of July, because this is the deadline to file possession proceedings, which is the court claim form for any valid Section 21 notices served before the 1st of May. And if you served a Section 21 notice and haven't issued a claim form by the 31st of July, the notice will lapse and become time barred. So don't miss this. And if you served a Section 21 notice before the 1st of May and you intend to rely on it, make sure that your solicitor has the claim form ready well in advance of the 31st of July deadline, because they're all going to be very busy on that last day. I know there's a lot to take in, and the Renters' Rights Act makes significant changes to the way we run our businesses. And as I said, my book, The Good Landlord Handbook, makes it easy for you to get your head around it and comply with the new rules going forward. You can read and reread it at your leisure. It's got lots of checklists, and I spell it out in really clear terms. It's the only book out there that combines a legal mind with the direct experience that I have of the practicalities of being a landlord. You can also keep up to date for free if you sign up for my free Friday newsletter at theindependentlandlord.com/subscribe. If you have any questions, you can ask me them at my twice monthly live streams in my membership, the Independent Landlord Hub, along with all the templates, checklists, and courses. Come and join us and see you soon, and hopefully in the hub.